Question: Congress passed Republic Act No. 1 to comply with the United Nations Convention on the Law of the Sea, establishing the baselines of the country. In a petition filed with the Supreme Court, Professor Juan de la Cruz, representing an NGO that serves public interest, argued that Republic Act 01 is unconstitutional as it discarded the definition of the Philippine territory under the Treaty of Paris and other related treaties, excluded the Kalayaan Group of Islands and the Scarborough Shoals from the Philippine archipelagic baselines, and converted internal waters into archipelagic waters. Is the petition meritorious? Answer: The petition of Professor Juan de la Cruz is unmeritorious. In the landmark case of Magalona versus Ermita, RA 9522, otherwise known as the Baselines Law, was discussed and its constitutionality was further elucidated by the court. It mentioned that RA 9522 does not violate our Constitution. On the contrary, it established our territorial rights as an archipelagic nation, wherein the Philippines was considered a single unit instead of being fragmented into several units. Moreover, the Kalayaan Group of Islands were considered as a regime of islands, which is within our contiguous zone. The baselines were drawn to connect the outermost parts of the archipelago, which does not depart to an appreciable extent from its natural configuration. The enactment of this law was done in accordance with our duty as a member of the international community. Here, it is clear that the facts of the case fall squarely with that of Magalona versus Ermita, and thus it is respectfully viewed that such petition will not prosper. Question: In 2020, the government implemented a fiscal acceleration policy that authorized the realignment and transfer of funds between departments. As a result, surplus funds were allocated to various projects, including the construction of schools, hospitals, and bridges, as well as medical missions and scholarship programs. However, in 2022, the policy was challenged before the Supreme Court for its alleged unconstitutionality. If the Supreme Court declares the fiscal acceleration policy unconstitutional, what would be its legal and practical implications? Answer: If the fiscal acceleration policy is declared unconstitutional, the operative fact doctrine will apply. Since the funds were already utilized in good faith for public benefit, such as the construction of schools, hospitals, and infrastructure, it would be inequitable to require their return. The doctrine ensures that while an unconstitutional law has no legal effect moving forward, acts performed under it before its invalidation remain valid if done in good faith. In Araulo versus Aquino, the Supreme Court ruled on the constitutionality of the Disbursement Acceleration Program, DAP, and held that those who relied on it in good faith would not be penalized. Given the similarities in circumstances, the same principle applies here. Thus, individuals and institutions that benefited from the fiscal acceleration policy in good faith will not be required to return the funds or undo completed projects. Question: The Philippines became a member of the World Trade Organization and resultantly agreed that it shall ensure the conformity of its laws, regulations, and administrative procedures with its obligations as provided in the annexed agreements. This is assailed by Senator Reyes as being unconstitutional because this undertaking unduly limits, restricts, and impairs Philippine sovereignty, and means, among others, that Congress could not pass legislation that will be good for our national interest and general welfare if such legislation will not conform with the WTO agreements. Is the argument of Senator Reyes correct? Answer: No. Senator Reyes's argument is incorrect. As a member of the international community, the Philippines has constitutional obligations to international organizations. This principle is enshrined under Article 2, Section 2 of the 1987 Constitution, otherwise known as the Incorporation Clause, which mandates adherence to generally accepted principles of international law. In Tañada v. Zangara, the Doctrine of Incorporation was emphasized, affirming that municipal laws must conform to international agreements the Philippines has entered into. Similarly, in Magalona v. Ermita, the court upheld the idea that compromises on sovereignty may be made in exchange for greater international benefits, as long as they do not violate the Constitution. Therefore, Senator Cruz cannot successfully challenge the Philippines' membership in and commitments to the WTO, as these align with our constitutional recognition of international law. Question: Martha is the owner of a piece of land. Without prior expropriation or negotiated sale, the national government used a portion thereof for the widening of the national highway. Martha filed a complaint for recovery of property and damages against the Secretary of Public Works and Highways and the Republic of the Philippines. The defendants moved for dismissal of the complaint, contending that the government cannot be sued without its consent. If you were the judge, how would you decide? Answer: As a judge, I will rule in favor of Martha. The general rule is that the state cannot be sued without its consent, subject to certain exceptions. One such exception applies to eminent domain, where the government exercises its power to take private property for public use. In Amigable v. Cuenca, the Supreme Court held that the state may be sued in eminent domain cases if it fails to pay just compensation, as required by the 1987 Constitution. Otherwise, this would result in unjust enrichment on the part of the government. Additionally, when a case involves the release of public funds for a lawful obligation, the state may be held liable. Therefore, I will rule in favor of Martha, as the state can be sued in this instance. Question: A deadline was set by the COMELEC under Republic Act Number 8189, Voters Registration Act of 1996, for the registration of voters. A group representing the youth sector claimed that around 4 million youth failed to register on or before the deadline set by the COMELEC. Thus, they requested that additional days for registration be conducted. The COMELEC issued a resolution denying the request to conduct a 2-day additional registration of new voters. Aggrieved by the denial, the group filed a petition before the Supreme Court, which seeks to set aside and nullify COMELEC's resolution. Did the COMELEC commit grave abuse of discretion in denying the request to conduct a 2-day additional registration of new voters? Answer: No, the COMELEC did not commit grave abuse of discretion in denying the request. First, it must be emphasized that COMELEC is a constitutional body tasked with promulgating rules and regulations governing the conduct of elections. The deadline for voting, as set by Republic Act Number 8189, enjoys the presumption of constitutionality, meaning that lawmakers have already considered a reasonable time frame for voters to cast their ballots. In this case, granting a 2-day extension would directly contravene the deadline set by law. Since COMELEC's decision was made within the limits prescribed by law, it cannot be deemed a grave abuse of discretion. Therefore, the denial of the request was proper and legally justified. Question: Mr. Bean sued the Republic of the Philippines, represented by the Director of the Bureau of Lands, and asked for the revocation of a deed of donation executed by him in favor of said bureau. Mr. Bean alleged that, contrary to the terms of the donation, the donee failed to build an office building and parking lot in the property and allowed the use of the property by private entities. The Republic invoked state immunity and moved for the dismissal of the case on the ground that it had not consented to be sued. First question is, under the Doctrine of Immunity from Suit, the state cannot be sued without its consent. How may the consent be given by the state? And second, in the given problem, should the Republic's motion be granted? Answer: On the first question, it is important to emphasize that the state may not be sued without its consent, except when there is a law stating otherwise. For example, RA 3083, which pertains to money claims against the government, or when it commences litigation or entered into a contract, it is deemed to have descended to the level of an individual. The former pertains to express consent, while the latter pertains to implied consent. Second, in this case, the state may be sued. The facts clearly state that there is a deed of donation made in favor of the Bureau of Lands, which is considered as a valid contract, and thus an implied consent was given by the state because it descended into the level of an individual by entering into the contract. Further, the fact that it is also used by private entities means that it is not purely used for governmental purposes, and that a proprietary purpose is involved, which strengthens the claim that it can be sued. Question: LeBron James, an American basketball star, visited the Philippines. Noticing the country's deep passion for basketball, he expresses his desire to play for the Philippine national team. Enthusiastic about the idea, Congressman A promptly files a bill granting James Filipino citizenship. However, Congressman B opposes the bill, arguing that James must follow the legal process and demonstrate that he meets the qualifications for naturalization while having none of the disqualifications under CA number 473. Is Congressman B's objection valid? Answer: Congressman B is incorrect. First, it is important to identify the different types of naturalization. CA 473 pertains to judicial naturalization as a mode of initially acquiring citizenship for aliens continuously residing in the Philippines for at least 10 years. RA 9139 pertains to administrative naturalization for aliens who are born and raised in the Philippines. Lastly, legislative naturalization pertains to an act of Congress granting citizenship to an alien for his or her valuable contribution to our country. In the case at bar, the qualifications and disqualifications mentioned by Congressman B only pertains to judicial naturalization. It is clear that LeBron is being legislatively naturalized, and thus, CA 473 will not apply. It is subject to the wisdom of Congress, similar to how a bill is passed. Therefore, it is clear that Congressman B's argument does not hold water. Question: Marcus was born in the Philippines to an American father and a Filipina mother. Over the years, he built a successful career and accumulated significant wealth through various business ventures. Aspiring to serve the public, he decided to run for office in the upcoming elections. To preempt any challenges to his citizenship, Marcus filed a petition before the regional trial court seeking a judicial declaration recognizing him as a Filipino citizen. Will his petition be granted? Answer: No, the petition of Marcus will not prosper. The facts of this case are similar to Republic versus Sagun, wherein the court ruled that judicial recognition of citizenship in the RTC is not recognized. The next best thing for him to do would be to emulate what the court held in the case of Panisi versus Bureau of Immigration, wherein a recognition of citizenship in the said bureau was acquired by the petitioner and was deemed as valid by the Supreme Court. Therefore, in applying the relevant jurisprudence in the instant case, it is viewed that the petition of Marcus will not prosper. Question: During the May 9, 2022 elections, Mr. X filed a petition to disqualify Mr. Y and his party mates for engaging in election campaigning before the official campaign period. Mr. X alleged that on March 29, 2022, a day before the campaign period began, Mr. Y and his party held a motorcade, announced their candidacies, and urged voters to support them. Mr. Y denied the allegations, admitting that a motorcade took place but claiming it was a common practice in nearby areas following the filing of certificates of candidacy. He argued that no speeches were made, only music was played, and candidates were merely presented to the public. Despite this, the COMELEC disqualified him for premature campaigning. Mr. P challenged the decision before the Supreme Court. Was the COMELEC correct in disqualifying him? Answer: No. The COMELEC erred in disqualifying Mr. Y. As held by the Supreme Court in the case of Panera versus COMELEC, premature campaigning does not apply to individuals who have yet to file their certificates of candidacy. Here, it is clear that the alleged act of premature campaigning involving the motorcade was done prior to Mr. Y being declared as a candidate. Therefore, in applying the relevant case law, it is submitted that the COMELEC disqualification was erroneous. Question: Lucas, the incumbent congressman of the province of Cebu, decided to run for governor. Without resigning from his position, he filed his certificate of candidacy and continued performing his duties as a legislator, including attending sessions and committee hearings. One of his strongest critics, Mark, argued that Lucas should no longer exercise his congressional functions because he is deemed ipso facto resigned upon filing his COC for governor. Is Mark's argument correct? Answer: The argument of Mark is not correct. The two relevant cases that should be cited for this problem would be Farinas versus Executive Secretary and Quintos versus COMELEC, both of which pertains to the distinctions of an elective and appointive official with respect to seeking an elective post. It was ruled that only appointive officials are deemed resigned to avoid conflict with partisan political activities, while an elective official remains in his or her post. Here, it is clear that the congressman is an elective official, and therefore the ipso facto resignation does not apply to him.